Good afternoon. My name is Paweł Wiliński, and I have a pleasure to chair this fourth session of the conference. So after a very short break, resulting from very interesting discussion that we had at the third panel, the third session that was on memory law, protection of moral rights, we come to the fourth session, and we will have two speakers. The session is Look Who's Back, Political and Constitutional Problems of Preventing Nazi Revival. And we will have two speakers, Professor Brigitte Bailer-Galanda, that will hopefully join us later, and Dr. Janusz Roszkiewicz. We will speak about the Nazi revival, we will speak about genocide denial, and we will speak about the Holocaust denial from different perspectives, from the national perspective of Austrian law and Austrian experiences, from Polish perspective, but also from the constitutional perspective. And we will start with the presentation given by Dr. Janusz Roszkiewicz, Assistant Professor at the Human Rights Center at the University of Warsaw. He's specializing in public law and medical law, and he is also an expert at the Supreme Court of Poland. The topic of the presentation is the constitutional problems of outlawing political organizations affirmative of Nazi legacy. Dr. Roszkiewicz, please, you can start.
Thank you very much, Professor. First of all, I would like to thank for the invitation to this prestigious conference and for allowing me to present my thoughts on constitutional problems of outlawing Nazi organizations. My speech will consist of 4 parts. In the first one, I will make few introductory remarks, including selected examples of Nazi organizations which are active till today, and also a few words about definition of Nazi ideology. In the second part, I will address an issue of problems concerning defining organizations as Nazi ones. I will ask question, what kind of features make an organization a Nazi organization? In the third part of my speech, I will speak about abuse of the freedom of association and freedom of expression, of course, in the context of activity of contemporary Nazi organizations. And in the last part, I will say a few words about Nazi organizations which are operating in a peaceful manner. We need to ask ourselves the question whether only the activity which is based on violence should be illegal, or perhaps we should speak about this issue more broadly and also outlaw Nazi organizations which act in a peaceful manner. This is a question about boundary between activity and the program. So, cut to the chase. 75 years after the end of World War II, Nazi ideology may seem like yesterday's news. But nowadays, it seems unimaginable that in any country in the world, a political party or association which advocates Nazi program could gain any support of the society. And yet, as experience has unfortunately shown, Nazi organizations are still active in many countries, although they enjoy a marginal support. And let's look at few examples. Among them, for instance, we can find the Combat 18, neo-Nazi terrorist organization, which originated in United Kingdom, but is still active in countries such as United States, Canada, or Germany. Another example, the Reichsschau Volunteer Force, a splinter group of Combat 18 active in Belgium. The Nationalso-cialist movement of Denmark. Its official radio station was supported by public funds till 2004. Since then, however, this radio remains operational because it's funded from donations coming from private donors. Another example, the Nordic resistance movement, which is active in Scandinavian countries, at least since 90s, which has been banned in Finland in 2019. So for a very long time, this organization remained completely legal in Finland. Another example, the Autonome Nationalisten, German Nazi organization, which is active since 80s till today. Another example, the Adgemeinschaft, Germanic faith community, which is active in Germany since 50s, still till today. And last example, the Slavic Union, active in Russia since 1999 and banned in 2010. And now a few words about definition of Nazism. Nazism, in other words, National Socialism, is an ideology formulated in Germany, but inspired by Italian fascism. And the most important characteristics of this ideology include revolutionism, meaning strive to overthrow the traditional social order and to create new state, new society, and new culture. Second feature of Nazism is, of course, racism, anti-Semitism, anti-democracy, eugenics, chauvinism, socialist model of the economy, state interventionism, subordination of an individual to the state, anti-Christianism, and instead neo-paganism combined with the cult of personality, and last but not least, totalism, which I define as regulation by state almost all areas of social and private life. Interestingly, many researchers qualify Nazism as right-wing ideology. In my opinion, this view is incomprehensible because the postulates of classical right movement go in a complete opposite direction to Nazism. And these right-wing postulates include economic liberalism, the primacy of individual freedom, limitation of the role of the state in society and economy, evolutionary, not revolutionary way of introducing and pursuing policies. And some right-wing trends also refer to in their programs to moral conservatism, especially Christian values. Not all, but some. Meanwhile, almost all the features of Nazism are characteristic of the political left, such as economic socialism, paternalism of the state, the desire to overthrow existing social order, for example, new concepts of family, sex, gender, culture, society, and certain aversion to Christianity. Of course, I am not saying that being left in political views means being Nazis. No, I just say that it's not fair to treat Nazism as a part of right-wing movement because it's more similar to the left wing, which does not mean that it's the same. It's more similar to the left wing than to the right wing. In this context, I would like to outline three main constitutional problems which are related to the outlawing Nazi organizations. Firstly, definition. What features make a political organization a Nazi one? Is a single feature of Nazis sufficient to ban the party? Well, in my opinion, we have to distinguish between fundamental primary features of Nazi and secondary, less important, less characteristic features of Nazi. Obviously, most fundamental features of Nazism are postulates such as anti-Semitism, racism, chauvinism, revolutionism, and totalism. So any movement, party, or any type of association which represents at least one of these postulates can be considered as a part of Nazi movement. While organizations which represent only secondary features of Nazi program, well, here there would be a problem to identify them as National Socialists. The next problem is more complex because it addresses constitutional and international rules of limiting human rights, especially freedom of expression and freedom of association. On the one hand, both in constitutional law and international law, boundaries of freedom of speech are extremely broad. They include right to insult and even right to express controversial and shocking views. On the other hand, it has never been doubted that not every statement or activity is protected by the law. The question is where to draw the line between controversial but permissible view and the abuse of freedom of association or freedom of speech. Even in the era of broadly interpreted freedom of speech, which allows for the proclamation of controversial, shocking, and offending views, not every statement is tolerated today. Both freedom of association and of expression might be limited, provided that they pursue a legitimate aim recognized by the law, and provided that they are proportional to the aim pursued. What does it mean, proportional? Well, international and constitutional law says that proportional means absolutely necessary to pursue this aim, to achieve this aim, and adequate and effective to achieve this aim. However, international law contains also an additional way out from freedom of expression guarantees, which allows to exclude completely certain categories of expression from legal protection if they are intended to destroy the freedom itself. And this way out is known as abuse of right or abuse of right clause. In this clause allows us to abandon entirely analysis whether the limitation is proportional or not, and allows us to a priori, a limine, declare that certain types of actions fall completely outside of protection of the law. For obvious reasons, this type of clause should be applied with extreme caution and restraint. And also for obvious reasons that there is no exhaustive catalog of situations, activities considered as abuse of rights. But thanks to the European Court of Human Rights case law and case law of another international institutions, we have few examples which are worldwide considered as abuse of freedom of expression or freedom of association. And among them we find, firstly, promotion of totalitarian ideologies, quite obviously. Secondly, expressing support for historical revisionism regarding Holocaust or another German atrocities committed during World War II. Thirdly, as abuse of right is considered also racism, anti-Semitism, or Islamophobia. And fourthly, incitement to violence also is considered as abuse of right. And in all these cases, we do not apply proportionality standard. We do not conduct whole analysis of whether the interference with the right is proportional, but we a limine exclude this type of expressions as completely unacceptable. Both European Convention on Human Rights and International Covenant on Civic and Political Rights, the most important international treaties regarding human rights in the world, both these treaties allow using abuse of rights clause. Article 17 of the Convention and Article 5 of the Covenant explicitly allow to completely outlaw certain political expressions and activities as unacceptable in a civilized society. However, international standards need to be implemented in hundreds of specific legal environments where numerous national constitutions lack provisions concerning abuse of right. For example, in Poland, in France, or in the United States, which begs the question whether any political program or activity can be recognized as a limine deprived of any constitutional protection. Can we use or invoke abuse of rights clause in constitutional legal order when there is no explicit legal basis? Well, in my opinion, the answer is yes and no. Yes, we can, even in such constitutions which lack abuse of rights clause, we can exclude totally certain activities and expressions from the protection of the law. But no, we cannot invoke abuse of rights clause because such radical restrictions on human rights cannot be presumed. They should be based on explicit legal basis. But in lack of such clause, we can and we should apply proportionality standard to assess necessity of outlawing certain types of organizations, such as organizations of Nazi legacy. And I am certain that in all cases when truly Nazi organizations would be assessed, in all cases an interference and a ban of such organizations would fulfill proportionality standard. And the last problem I would like to address concerns the question, should only the activity or also the program be controlled? In other words, can Nazi organizations which operate in a peaceful manner be tolerated, or should they be fought on an equal footing with Nazi terror organizations? In spite of appearances, the answer to this question is not so obvious, because we should take into account famous or perhaps infamous ruling of the American Supreme Court ruling in the case of Nationalso-cialist Party of America versus Village of Skopje. And in this rulings, American Supreme Court quashed judgments rendered by courts of state of Illinois, which prohibited Nazi demonstrations with swastika on the streets of a certain city. And the consequence of those ruling was new judgment of Supreme Court of the state of Illinois, which stated that swastika falls within protection of the freedom of speech clause provided in First Amendment of the U.S. Constitution. So, for certain esteemed lawyers, esteemed courts, Nazism can be protected by freedom of speech and freedom of association. On the other hand, practice shows that states in the case of peaceful activities of Nazi organizations are less inclined to eradicate this type of association. So United States are not an exception. Perhaps there is this one famous ruling, but when we analyze the policies the European countries pursue in regard of certain Nazi organizations, then we will see that surprisingly several Nazi organizations are tolerated if they act peacefully. In my opinion, the reasons for this situation should be seen rather in politics than in law. From a purely political point of view, it may not pay off for the government to get in the open war with niche organizations that hold dangerous views but affect a marginal part of society. Legally, however, typically Nazi organizations should not be tolerated, in my opinion, even if they operate peacefully. There are few issues on which international community is so unanimous, and one of these issues is Nazism. Almost, perhaps even all members of international community consider Nazism as barbaric, immoral, aggressive and degrading ideology. So, therefore, it cannot be tolerated, even if its supporters are acting peacefully. There are no legal reasons to allow to protect such form of expressions. There are no values which would be a basis for tolerance policy towards such organizations. Since the law determines boundaries of freedom of expression and speech, inter alia it offers us abuse of rights clause, we should take advantage of it and outlaw organizations promoting totalitarian ideologies. Thank you very much for your attention.
Thank you, Dr. Roszkiewicz. As we all have heard, the Nazi organizations and their existence are still waking our interest and opening many questions that we should and could ask. And I hope we'll have time for that. But I'm very happy to see that we have Professor Brigitte Bailer-Galanda with us already. Hello and good afternoon. Can you hear us?
I can hear you, yes. I'm sorry.
Okay.
Thank you, Prof.
We're very happy to have you with us, and taking this opportunity, I will, after the short presentation, give you the floor. Professor Brigitte Bailer-Galanda is historian and social scientist. She is a member of staff of the Documentation Centre of Austrian Resistance, of which from 2004-2014 she was academic director. She is also a lecturer at the Institut of Contemporary History, University of Vienna. And the research topic is the prosecution and resistance between 1938 till 1945, Austria's dealing with the National-Socialistic past, and right-wing extremism in Austria, especially Holocaust denial. The title of this Today's presentation is From Denazification to Banning of Holocaust Denial, the Austrian Law Against Nationalso-cialist Activities. Professor Bailer-Galanda, you're welcome.
Thank you very much. I'm terribly sorry for the technical problems with my computer. Now I'm trying with my mobile phone, and that's a bit difficult. And thank you very much for the invitation to this interesting conference on a recently much discussed topic. The Austrian law I'm presenting today is a very special case concerning memory laws. First, it is the oldest one, dating back already to 1945. Second, its first main task was the purge of society of National Socialists and National Socialism. And third, it turned into memory law as late as in the 1980s, when Austria was confronted with the rise of Holocaust denial. In 1945, the then provisional government of Austria declared Austria's independence on April 27th, and the Cabinet Committee passed the Gesetzesverbot der NSDAP, Act on the Prohibition of the NSDAP, the DAP, on May 8, the day of surrender of the German Reich. Alongside the ban of the party and all its auxiliary organizations, as well as any new engagement in NSDAP-related activity, the so-called Verbotsgesetz required National Socialists to be registered and included atonement measures. Essential of the Verbotsgesetz was to purge political, economic, and social life of National Socialists and their influence. But the denazification process, which was supposed to be carried out schematically according to specified criteria, soon revealed its limits. A revised version was passed in February 1947. The State Treaty of 1955, which granted Austria her full independence again, ultimately opened the way to a comprehensive Nazi amnesty, until then having been blocked by the Allied forces. The NS-Verbotsgesetz, the new name National Socialist Prohibition Act, had thus achieved its primary historical task. But those parts of the Act that impose penalties for re-engagement in National Socialist-related activity have been unaffected by these amnesties and continue to make the Gesetz relevant to current conditions in Austria as well. Section 3 of the original version of the 1945 Verbotsgesetz already contained a provision regarding re-engagement in National Socialist activity. In the amended version of the Act of 1947, this originally very brief provision expanded to become sections 3a to 3g. Sections 3a to f enshrined the ban on the re-establishment of a National Socialist organization, the support of any such organization. But however, state prosecutors and courts in most cases used the very broadly worded and very generally worded catch-all provision of the section 3g for prosecuting neo-Nazi activities. Beginning in the 1980s, they also applied it to Holocaust denial. The paragraph said, I cite, whoever is active in a National Socialist sense shall, unless the act is not subject to higher punishment, be punished with imprisonment. The elements of the offense detailed in Section 3 and the associated threat of punishment remain in force until today. Shortly after the end of the war, those provisions that relate to the re-engagement in National Socialist activity were used for the first time against the so-called werewolf group, centered around a former member of NSDAP, Hitler USA. After numerous German nationalist and right-wing extremist organizations succeeded in re-establishing themselves in the early 1950s, the democratic public was confronted by a resurgence of organized right-wing extremism. The security services reacted to events organized by those groups by dissolving numerous militant right-wing extremist organizations, but not on the basis of the Verbotsgesetz, but instead using other legal measures like the Act on Association. Following decades, the Verbotsgesetz itself rarely invoked. Between 1901 and 1967, the number of indictments and trials under the Gesetz declined almost constantly, so that the Ministry of the Interior stopped collecting statistics on it all. At the same time, the 1960s witnessed a steep rise in right-wing extremism and neo-Nazism. The paucity of trials under the Verbotsgesetz during these periods is thus clearly related to the tolerance and acquiescence displayed by the government and civil society toward even militant right-wing extremism. It also indicated that public officials were reluctant to initiate legal action against such groups. But since the 1970s, the neo-Nazi, racist and aggressively anti-Semitic press had become more prominent. In the 1980s, prominent figures of this field turned to propagating Holocaust denial, which they tried to spread in Viennese schools. In response, school administrators called upon historians and Holocaust survivors to produce informational brochures to counter the denial and distortion. At the same time, a neo-Nazi group had been established at the Vienna University. Soon, proceedings against this group demonstrated that the Verbotsgesetz could be used against both individuals and political parties, though the latter were partly protected by the Austrian law on political parties. A trial conducted in 1984 against functionaries of this group ended with the conviction of the group's entire leadership. A year later, in 1985, the Constitutional Court issued a landmark verdict. The court ruled that the ban on re-engagement in National Socialist activity is an all-embracing requirement of all state acts. And that was finally a breakthrough in the Verbotsgesetz all over the place. Following this verdict, neo-Nazi parties were stripped of their status as political parties, a decision that eliminated any further legal obstacles to their dissolution. However, in the 1980s, the authorities still ran into problems in applying the ban on re-engagement in National Socialist activity to individual activists or newspaper publishers who, even if they openly denied the Holocaust, this did not result in criminal convictions. The fact that Section 3G of the Verbotsgesetz was phrased, as I stated above, in a vague way, appears to have contributed to the difficulties that prosecutors encountered. During the 1980s, some Austrian historians, as well as international historians, turned their attention to Holocaust studies. Official and judicial powerlessness is of blatant, unrepentant Holocaust denial, which at the very least represented a mockery of and insult to the victims, provoked severe criticism, especially by Holocaust survivors like Hermann Langbein or Simon Wiesenthal, the Jewish community and the institution I'm representing today, the Dokumentationsarchiv of Austrian Resistance. In May of 1990, a conference on the topic of suitable statutory measures for combating Holocaust denial was held in Vienna. The conference's findings and recommendations were taken up in the parliamentary process that followed shortly afterwards. Ultimately, members of parliament made a compromise motion, which resulted in an amendment to the Verbotsgesetz being passed on February 26, 1992. This amendment reduced the minimum punishment provided for in the law, while adding, and that was important, a new provision that threatens to punish, I cite, whomever attempts to deny, grossly downplay, condone, or justify the National Socialist genocide or other National Socialist crimes against humanity in a printed work, in the broadcast media, through another medium, or through any other public channel, and does so in a manner that it is accessible to many people. And that was the real turning point. That amendment constituted a breakthrough. Prominent neo-Nazi figures could be successfully tried in the follow. Statistics show that the Verbotsgesetz has since then become an instrument that is constantly deployed in re-engagement in National Socialist activity and Holocaust denial. The conviction of leading neo-Nazi propagandists in the aftermath of the 1992 amendment had some positive direct consequences in restricting the spreading of neo-Nazi propaganda and Holocaust denial, even in digital media. For example, in January 2013, the Vienna Landesgericht Regional Court convicted those behind a for some time extremely active neo-Nazi website called Alpen-Adria-Universität. About a third of the convictions due to the law concern neo-Nazi content in social media, Facebook, Twitter, or recently more often used Telegram, TikTok, and others. The comparatively higher number of indictments made and trials conducted over recent years probably has less to do with increased crime than with the more stringent application of the verbots and the heightened sensitivity on the part of the public police authorities. Nevertheless, there is criticism of the Verbotsgesetz, I would say, of course, on the side of right-wing extremists, because they correctly view the law as a brake on their activities. However, there are also those who criticize the Verbotsgesetz as a classically liberal perspective. In this view, the Austrian people could also be trusted to resist the resurgence of National Socialist ideology without court involvement. In contrast to some other memory laws, which sometimes clear political motivation, the Austrian prohibition on re-engagement in National Socialist activity and the associated ban on denying socialist crimes of violence occupies a completely different historical and political context. The Austrian Verbotsgesetz in no way impairs either serious historical research or academic freedom. No serious historian would deny the Holocaust or other National Socialist crimes against humanity. Indeed, the assertion that the Verbotsgesetz restricts the right of free expression was rejected by the Constitutional Court as early as 1985. Later, even the European Court for Human Rights ruled the same when people convicted because of the Verbotsgesetz appealed it. Those who re-engage in National Socialist activity and Holocaust denial follow the ultimate aim to absolve Nazi ideology of the most serious crimes committed in its name and, in doing, to make it acceptable once again. In this way, an opinion becomes a political intention. I quote, "The ban on the Auschwitz lie," writes the historian and writer Doron Rabinovich, "is aimed at the global hate preachers of our time, because the fable of the so-called Auschwitz lie has long become today's blood libel. The intentional denial of the crimes is not an opinion, but a slogan of hatred. It assumes a global Jewish conspiracy. It is a symbol of identity, just like the swastika or Nazi salute. All survivors, all Jews are branded as fraudsters. The mass murder is disputed despite knowing better, so that appetites are whetted for the next one." I think I'll finish with that, and I'm open for any question you might have for me. Very much.
Thank you very much, Professor Bailer-Galanda, for this very interesting presentation about the denazification and Holocaust denial. Unfortunately, there is just 5 minutes left, but if I may, I would like to ask one question to both of the speakers, starting with Professor Bailer-Galanda. While listening to your presentation, the question came to my mind, and I wonder how about genocide denial other than Shoah, the other than Holocaust denial? We have this law in Austria from 1992 prohibiting any public denial of the Holocaust and other National-Socialistic crimes. Do we have any research in Austria about the genocide denial other than the Holocaust denial? Can you?
There is research at the University of Vienna. There are a lot of colleagues are researching on genocide and doing comparative studies on genocides. But the law aims at the denial of the National Socialism. And since the mass murder of the Roma in Sinti, National Socialism never denied until now. And the mass murder of people with handicaps was never denied until now. There was no indictment by any court concerning these crimes of socialism. But I think I might be quite sure that denying these crimes will be a topic for courts according to the Verbotsgesetz as well. But other genocides, like the genocide in Rwanda or the genocide on the Armenians, which is disputed by Turkey, is a topic and is not dealt with by the Verbotsgesetz.
Yes, and how about the other genocide acts committed during the period of the same time that the Holocaust denial? I mean, there have been much more atrocities during the Second World War than only the Holocaust, which was obviously well-known and horrible sum of accidents. However, there is much more of that. Is anyone in Austria interested in this part of denial of the genocide and responsibility?
Now we are coming into a debate how to define the term genocide. There is, I think, other mass atrocities by the National Socialists against Poles, against Russians, against Ukrainians, against a lot of other nations in Europe. Was the definition of genocide mass atrocity, mass murder, but not genocide. But if that would be denied because the law says any other crimes of National Socialists, I think that could be followed up by the law as well. But of course, there's research on other forms and other mass atrocities and other National Socialist crimes done in Austria, not at my institute, but for instance at the Vienna Wiesenthal Institute, at the universities, and mainly Wiesenthal Institute and various university institutes in Austria.
Thank you, Professor. And I will refer, sadly, only one question to Dr. Roszkiewicz that had a very interesting presentation about the Nazi organization and the limits of legality from the constitutional point of view. It's not easy to choose question. However, probably I will concentrate on the freedom of speech. And the freedom of speech with its constitutional understanding or international law understanding. The question is whether the trigger element of the freedom of speech and understanding of the constitutional guarantees is not the sensitivity of the issue to the society, if the issue is sensitive, like in Poland or in Austria, the Holocaust denial, have anything in common with the freedom of speech, with understanding the freedom of speech and the limits of the freedom of speech?
If I understood your question correctly, you're asking whether the sensitivity of the issue has certain influence on the limits of protection of freedom of speech. Yes?
Yes.
Mm-hmm.
In other words?
Well, yes. Okay. In general, obviously, yes, because in European Court of Human Rights case law, there is a standpoint view according to which issues which are controversial in certain society from the moral or social point of view remain within margin of appreciation of the states, so they can regulate it in a manner which they choose, in whichever manner they choose. But the Strasbourg court applies this rule to the issues which are really controversial for the society. Issues such as abortion, euthanasia, or vaccines and duty to get vaccinated against certain infectious diseases. But issues such as Nazism do not really are so controversial. They remain perhaps controversial among very small groups of certain societies, but there is international consensus on the matter that Nazism should not be tolerated. Nazism or any forms and consequences of Nazis, such as Holocaust denial. So, in conclusion, I think that the sensitivity argument in case of Nazi ideology does not apply.
Thank you so much. Before we'll finish this session, I will just ask if, while reading your written report from that session, you could answer also the question about what is the Nazi element in defining Nazi organization. You put that question during your presentation, that there are doubts in definition, what feature make a political organization a Nazi one. I would be very interested in reading the answer for that, because we have some feelings, but once we speak about legal regulations and legal responsibility, this feeling is not enough. So what is, in your opinion, this Nazi element that constitutes Nazi organization? And with this unfortunately unanswered question, I have to leave our guests today because we are off the schedule already. So thank you, Dr. Roszkiewicz, thank you, Professor Bailer-Galanda, and now we will have a coffee break. According to the schedule, we will start the 5th session at 4:35 p.m. Thank you very much.